Good afternoon. And for those of you who are here as our guests, welcome to the University of Georgia School of Law. My name is Beau Rutledge. I'm the Dean of the Law School. And I'm pleased to welcome you here today for a lecture from Professor David Strauss, one of the nation's premier scholars in the field of constitutional law, one of the nation's premier advocates before the Supreme Court of the United States, and a good friend and mentor to me. Our mission at the law school is simple. It is to produce world-class ideas, to provide first-rate legal training in service to state and society, to do this at a good value and to be buoyed by the authentic relationships with our alumni and friends. In today's lecture, the 117th in the history of the John Sibley Lecture, is a fitting tribute to that mission. In 1964, the trustees of the Charles Loredens Foundation of Atlanta established the Sibley Lecture in tribute to the late Professor John A. Sibley, a 1911 graduate of this law school whose portrait adorns the third-floor hallway around the corner from the courtroom. While the trustees of the Loredens Foundation were unable to attend today's event, I would like to take a moment to acknowledge the support of two of them, Mr. Harvey Hill, a longtime trustee of the foundation, and Mr. Bob Edge, the chairman of the foundation, who has for many years been a great friend to the law school and the University of Georgia. Thanks to the Loredens Foundation, this lecture series honors the leadership and public spirit of John Sibley, whose service to the law school and to the state of Georgia extended over a period of nearly 80 years. Since its establishment, the Sibley Lecture Series has attracted truly world-renowned legal scholars from around the country to visit and speak on a variety of topics. These include Supreme Court justices like Ruth Bader Ginsburg, Harry Blackmun, and Antonin Scalia, legal scholars like H.L.A. Hart, John Hart Ely, and public servants like President Jimmy Carter, not to set the bar too high for Professor Strauss. Today we are pleased to welcome Professor Strauss, the Ratner Distinguished Service Professor of Law and the Director of the Jenner and Block Supreme Court and Appellate Litigation Clinic at the University of Chicago. At this time, I'll turn it over to my colleague, Associate Dean Elizabeth Weeks, to provide a fuller introduction of Professor Strauss. Welcome again.
Thank you, Dean Rutledge, and thank you all for being here. It is my privilege and honor to introduce this year's Sibley Lecturer, Professor David Strauss. As the Dean mentioned, Professor Strauss is the Gerald Ratner Distinguished Service Professor of Law and Faculty Director of the Jenner and Block Supreme Court and Appellate Clinic at the University of Chicago Law School. Professor Strauss joined the University of Chicago Law faculty in 1985, where he teaches constitutional law, federal jurisdiction, elements of the law, and administrative law, as well as civil procedure and torts. He is a prolific author of articles, book chapters, and various other pieces on a variety of subjects, principally in constitutional law and related areas. He also has published a book, The Living Constitution, with Oxford University Press in 2010, and has a forthcoming book, Democracy and Equality, The Enduring Constitutional Vision of the Warren Court, also with Oxford, forthcoming in 2019. With Jeffrey Stone and Dennis Hutchinson, Professor Strauss also serves as editor of the Supreme Court Review. Professor Strauss graduated from Harvard College, summa cum laude. He then received a Bachelor's of Philosophy and Politics from Magdalen College at Oxford. Next, he graduated magna cum laude from Harvard Law School, where he was the developments editor of the Harvard Law Review. Before joining the Chicago Law School faculty, he served as attorney advisor in the U.S. Department of Justice Office of Legal Counsel, assistant to the U.S. Solicitor General, and special counsel to the U.S. Senate Committee on the Judiciary. We are also delighted to welcome back to campus Professor Strauss's wife, Benna Solomon, who is a UGA Law alumna, a 2016 recipient of the law school's Distinguished Service Scroll, and presently Deputy Corporation Counsel for the Appeals Division of the City of Chicago Law Department. And Ms. Solomon also has logged a number of U.S. Supreme Court arguments as well. As one of the news articles discussing this renowned couple mentioned, this is the equivalent of having, the legal equivalent of having two Ironman triathletes in the same house, training for races just days apart. So thank you both for being here, and thank you all for attending.
Bo, thank you very much for your introduction. Elizabeth, thank you very much, and thank you for doing all the arranging. Bo was a student of mine longer ago than either of us, I think, is going to want to remember. And, you know, he was a nice guy then and a very smart guy then, and it's nice to see some things haven't changed. And Elizabeth has worked tirelessly to put this together. I'm very grateful to her for all her work and encouragement and hospitality. Also wanted to thank Nico Terry, who did the arrangements, and I wanted to say something about Benez and my friends Dan and Sally Coonan, there are many, many reasons why we love coming back to Athens, and they are right at the top of the list. My subject today is the question, are Supreme Court decisions the law of the land? I guess I could imagine people having three reactions to that question. One reaction would be, yeah, of course. I mean, what are we talking about here? That's how you know what the law is. We have an argument about something, you know, can a baker who has a conscientious or religious objection to baking a cake for a same-sex wedding refuse to do so even if state law would require him otherwise to do it? That's a disputed legal issue. We argue about it, we litigate about it, and then the Supreme Court decides it, and then we know what the law is on the subject. So why is this even a question? That would be one possible, plausible response. A second response would be, well, wait a second. The Supreme Court decisions aren't the law of the land. The Constitution is the law of the land. That's where you look. And Supreme Court decisions are efforts to get at what the Constitution is saying, but it's not the decision that's the law. The Constitution is the law. And then I guess a third response would be, well, that's naive. Everybody knows maybe the Constitution is the law of the land. Sure, it says it right there in the Supremacy Clause, but everybody knows the Constitution is what the judges say it is. So that's your answer, that Supreme Court decisions are the law of the land because the Constitution is, and the judges tell us what the Constitution says. So I guess I want to say that all of those responses are in some ways really not quite right, but also have an element of truth to them when we're trying to figure out whether Supreme Court decisions are the law of the land. Let me be a little more specific about just what the question is, since that's a pretty vaguely phrased question. Here's what I have in mind. The Supreme Court is a court, and what it does is decide cases and render a judgment in favor of one party and against another party or parties. It doesn't issue decrees which are then enforced by an army of bureaucrats. There are other parts of the government that operate that way. They will decide on a policy of general application and people will go out and implement it, whether those are police officers or officials of an administrative agency. That's not the way the courts work. They render judgments. Now, I'm going to assume what is generally, although not universally acknowledged, which is that when the Supreme Court renders a judgment against someone, that someone has to comply with the judgment or they will be held in contempt, and they have a duty to comply with it. So if you are sued and you lose, and whether you are an individual or that baker or a school board or the head of the EPA, and you sue and you lose a case in the Supreme Court, you have an obligation to comply with that judgment. As I said, that's not 100% uncontroversial. There's some people who will give you an argument about that, and I'll say a little bit about that later, but let's just assume that for now. The question is this: what about if you're not a party to the case, but it is very clear you are doing the kind of thing that the Supreme Court said you can't do, but you haven't been sued yet, and there's no judgment against you? Can you lawfully continue to do that, even though the Supreme Court has said that kind of behavior by the government is unconstitutional? Can you say, well, as a government official, can you say, well, I disagree. I've taken an oath to uphold the Constitution. I disagree with what the Supreme Court has said about the Constitution. I'm going to continue doing what I believe the Constitution allows or requires me to do. And if I get sued and an injunction is entered against me or some other kind of order is entered against me, okay, I'll comply with that. But until I get sued, I don't have any obligation to change my view of what the Constitution tells me to do or allows me to do. I don't have any obligation to do that until an order is entered against me. Now, what about that? Is that okay? Is that consistent with an official's oath to uphold the Constitution? That's my question. That's the sense in which the question about Supreme Court decisions being the law of the land comes up, at least I think, most interestingly and in the ways that are most significant. One thing about this issue is that it has made some very strange bedfellows in American history. A position on this issue, the position I just articulated, the position that, well, the Supreme Court hasn't entered an order against me and I'm going to continue to comply with what I think the Constitution requires until an order is entered against me. That was a position taken, I think we can fairly say, by the best and maybe the worst of people in American history. It was a position taken by the defenders of Jim Crow segregation after Brown against the Board of Education, where many school boards and state government officials said, well, we think Brown was wrong. We think it was unlawful. We'll continue to operate our schools the way we want to operate our schools. If we get sued, we will fight the lawsuit. If we lose, well, okay, we'll comply with an injunction. But until we get sued, in order to comply, we're going to do what we think the Constitution allows us to do. So you might think, well, listen, I'm not getting into that company. If those are the people who take this view that the Constitution is something other than what the Supreme Court says, I don't want to ally myself with them, and that's a pretty reasonable position. But here's someone else who took that position, Abraham Lincoln. That's what I mean by the best and the worst in our history. After the Dred Scott decision, the infamous Supreme Court decision that held that people of African descent have no rights that white people in this country are obligated to respect, and that slavery is constitutionally protected and it would be unconstitutional to deprive slave owners of their alleged property and enslave people. After the Supreme Court said that, Lincoln said, well, okay, they have said that Mr. Dred Scott himself is a slave, and I guess I have to go along with that. Lincoln actually later equivocated even on that point. But he said, okay, I have to go along with that. But that's it. And as far as the rights of other enslaved people, I'm not buying it. And the Lincoln administration issued passports to enslaved people and to African Americans, despite the holding, very clear holding of Dred Scott that they are not citizens. You have to be a citizen to have a passport. The Supreme Court said people of African ancestry are not citizens. The Lincoln administration said, go fly a kite. We're issuing them passports. The Lincoln administration pushed for the abolition of slavery in the territories and in the District of Columbia, even though the Supreme Court had said slave owners have a property right that can't be taken away from them. So there's your conundrum. The position that what the Supreme Court said is not the final word on what the Constitution is was taken, as I said, by the best and the worst in our history. Lincoln's view was also adopted in less dramatic forms by several other presidents, and there's a story to be told there as well, I think, which I'll get back to also. Thomas Jefferson was very clear on this point, that he was president, he took an oath, he had an obligation to interpret the Constitution the way he wanted, the way he thought was appropriate, and that the judiciary at the time, which was packed with Federalists, appointees of the Federalist Party, enemies of his party, the judiciary at the time, including the Supreme Court, was not going to tell him what the Constitution meant. Andrew Jackson took that position in opposing the rights of Indians, took the position that he would his famous saying attributed to him was John Marshall, the Chief Justice, has made his decision, now let him enforce it. Franklin Roosevelt did not take the position in quite so dramatic a form, but certainly made no bones about saying that the Supreme Court had gotten the Constitution wrong when it struck down key elements of the New Deal. And during World War II, at one point, let it be known that he was prepared to defy the Supreme Court if the Supreme Court prevented him from executing some saboteurs who had landed on American soil, even taking this beyond the position I articulated to saying, you can tell me not to do it, but there's a war going on, I'm going to do it. So you do have this history of presidents not acquiescing in the idea that the Supreme Court can tell them what the Constitution says. Okay, so now, what do we make of all of this? I want to say that the way I want to approach this question is to assume we're dealing with people who are acting in good faith, that these are people who have taken an oath of office and are trying to act in good faith in compliance with their oath of office. And if you're thinking, yeah, all right, buddy, beam me up to that universe, where exactly do you find these public officials who consistently act in good faith? If that's your reaction, well, okay, I get that. But just, I think it's important to think of it from that point of view, at least at first. This is actually an issue, I think, that a lot of us who are teachers have these days in particular, especially teachers of constitutional law, when your students say to you implicitly or explicitly, it's not only students also, it's often a lot of fellow academics who say, why are you pretending that constitutional law is law? We know it's all politics. The judges and justices get appointed because of their political views. They vote along party lines. Any political scientist who's ever studied the Supreme Court will tell you that. Why are you pretending there's law here? And I think, there's obviously a point there, but I think you can't abandon the effort to give an answer to people who will say, look, I know a lot of people think it's all politics. Sometimes it is all politics. I want to do the right thing. I want to know what the right thing to do is. So what do I do when I'm trying to figure out what the Constitution requires or permits? Tell me what the right thing to do is. We have to have an answer to that person. We can't say to that person, it's not law, it's all politics, do what you want. We have to say, no, here's how you would go about doing it. And that at least gives us, if nothing else, a basis for criticizing the people who don't act in good faith. So that's why I'm adopting the position, which especially in this day and age might seem a little bit naive, that we're talking about, say, a president or another high government official who's taken an oath of office and sincerely says, I want to comply with my oath of office. I want faithfully to implement the Constitution. Now, what do I do about Supreme Court decisions I think are deeply, deeply wrong? Do I have to follow them? I admit I have to follow them in the particular case. Do I have to follow them in general? That's my question. Now, okay, what if that president, let's say, or other government official says, look, we're talking about the Constitution. There's a document. The Constitution is there. The court looks at it and does its best to figure out what the Constitution requires, but I'm going to do that too. Why do I have to accept what they say when I disagree with them? I've taken an oath, they've taken an oath. If you're talking about the president, it's the head of an equal branch of government. Why do I have to accept their interpretation of the Constitution over mine? I just don't see the logic of that. And nothing in the Constitution says judges get to decide. It doesn't say that. It says the Constitution is the supreme law of the land. It doesn't say Supreme Court decisions are the supreme law of the land. So why do I have to defer to their interpretations as opposed to my good faith interpretation? Now, you might be thinking, well, how exactly does this work? Do you just keep saying, well, I'm going to get Congress to keep passing gun control laws. I know they'll get struck down by the court, but by golly, they've interpreted the Constitution wrong. Let's just keep butting our head against that wall until maybe somehow they finally yield. And in any event, we will have made our point. Or, this is to some extent a strategy taken by opponents of the Supreme Court's decisions on abortion. We will keep passing restrictive abortion laws, and maybe someday, at some point, the court will come around to our way of thinking things. Well, there's some problems with that. The problem being you'll get sued, and in certain circumstances, damages and attorney's fees can be awarded against you. The president can't be held personally liable for actions taken in his role as president, but plenty of other public officials can be, and the president alone can't implement laws. So you get sued and you end up paying damages. The law is that you pay damages if you violate a clearly established constitutional right, and that is clearly established as the Supreme Court and the other courts have established it. It's no defense to say, yeah, I think the Supreme Court got it wrong. You'll still be held liable for damages. So you might be tempted to say, well, okay, even if in principle the president, say, or an executive branch official could strike out on a separate constitutional course, they're not going to do it. It would just be perverse and a waste of everybody's time and a waste of the official's own money. I think the reality is, though, a little bit more subtle than that, and there are ways in which this question about do I have to comply with what the Supreme Court says the Constitution is, as opposed to just complying with specific judgments, a question which it really has some real-world implications. So let me mention three, I think. One is this: there are everyday decisions made by government officials that never see the inside of a courtroom. They either don't see the inside of a courtroom because no one is standing to sue, or because the controversy will have disappeared by the time the case gets litigated, or because, pretty commonly, the action is done in secret and it will just never see the light of day. And there you can have, say, a government official with a very practical problem. I think I want to conduct this form of electronic surveillance of American citizens. It's going to be done in secret for legitimate reasons. I think the Supreme Court has been unduly restrictive in what it's said about when we can conduct electronic surveillance. I have a view of the Constitution. I can justify it to you. Here's my justification for it. I think it allows us to conduct electronic surveillance in circumstances in which the Supreme Court would not permit it. But I think we can do it. They won't find out about it, in all likelihood. Why can't I do it? If they do find out about it and tell me to stop, I'll stop, because I think you should have to obey court orders. But why do I have to obey their mistaken interpretation of the Constitution? And there you have a realistic scenario, I think, where this issue could come to light. A second example, a little bit more complicated morally and legally, I think, is actions that are just not detected. They aren't legally made secret, but they're just not going to come to light. So state and local government officials, let's say, who protect non-citizens from being apprehended in ways that violate established Supreme Court precedent about the power of the federal government over immigration, but they can be done in subtle, indirect ways that will never get found out. And they think these Supreme Court precedents are deeply wrong and offensive to our constitutional values, and they'll give you the argument. Can they do it? Saying, okay, if they find out, we'll obey a court order. But I don't see any reason to do it short of that. And lots of action like that, or not lots of action, but a fair number of actions, I think, like that can take place in very low visibility ways. They're not legally secret, but they're just done in subtle, indirect ways that are very unlikely to come to light. And then the third scenario, I think, would be a dramatic confrontation where a president directly challenges the court and says, yes, the Supreme Court has said this. I'm the president of the United States. I think they're wrong. I've taken an oath. I'm not going along with it. I will comply with specific court orders directed to specific officials, but until those court orders are entered, I will direct people who work for me in the executive branch to continue to enforce the law in the way I see fit. That's that scenario, which is more or less the Lincoln scenario, where this question could come up. Now, in those scenarios, what do we make of the idea that, look, I've taken an oath too? I think it's too simple. This is why I said at the beginning, I think those three views I outlined all have a partial truth, but only a partial truth. Routinely, people deciding what the Constitution means look to judicial decisions. It's a reflex, including in the executive branch, including in Congress. Can we do this, or is it inconsistent with the First Amendment? Well, let's talk about the various First Amendment decisions, a clear and present danger, and New York Times against Sullivan, and all of that stuff. Let's talk about that. That's the starting point, is to look to Supreme Court decisions. If you really took seriously this idea that I've taken an oath, I get to decide, wouldn't you be reopening everything? Why would you why would you as president or as an executive branch official have any obligation at all to pay any attention at all to the Supreme Court? Why the fact that the court has said something, why should that affect your decisions at all? Why wouldn't you start from first principles, basic points? Forget everything the Supreme Court has said. Why should I pay anything attention to the Supreme Court has said? Okay, I'll pay some attention to it in the same way I might pay attention to some law review articles. In fact, they should probably pay more attention to law review articles, don't you think? But the Supreme Court decisions don't make any difference. No one really thinks that. No one really thinks that your oath of office entitles you, in fact, obligates you to wipe the slate clean of anything the Supreme Court has said and just decide it as if you were the first person ever to consider these constitutional questions. But if you take that oath of office view seriously, why isn't that your responsibility? Why are you paying any attention to the Supreme Court, any more attention than you'd pay to anyone else who had said something about these questions? So no one really thinks that. In fact, you could push it even further. Why would a Supreme Court justice pay any attention to what previous justices and previous courts had said? They've taken an oath too. Why shouldn't they say, well, I know some other courts have decided these cases this way, but that's just someone's views. That's not law. I have an oath of office. I'm going to go back to the Constitution and figure out what I think it means. No one thinks that. It would be chaos. It's not a system that, I was about to say it's not a system that survives. It's not a system that ever come into being. People just don't approach these issues that way, in fact, however much they might pretend that they do. So what does that tell us? I think it tells us that behind this idea, I've taken an oath, I will decide what the Constitution means, behind that idea is a much, much too simple notion of what the Constitution is. The notion is, well, it's this document. I got it in my pocket. Well, I don't actually have it in my pocket because I don't believe in this stuff. But if I did, I'd have it in my pocket and I'd pull it out. It would be very well thumbed, and I'd flip it open and I'd say, "See here, it says this." That's what it, right? But it's not. That's not it. That's part of it. That's obviously an important part of it. That's obviously a starting point, but that's not the ending point. And in fact, the Constitution, as it really exists, is an accumulation of judgments made by lots of people besides the people who drafted it and enacted it. And that includes all these precedents, and those are part of the Constitution. And the courts act as if they're part of the Constitution, and the executive branch in ordinary days acts as if they're part of the Constitution, and Congress does, and the states do. And once you understand that the Constitution involves more than just, say, the text and the framers' understandings, once you understand the Constitution means more than just that, then this problem both becomes more complicated and becomes less dramatic. Then it's not just a matter of, well, hey, I took an oath, I get to figure out what it means. Yes, you took an oath. Yes, you get to figure out what it means, but the it is not just the document you're holding in your hand. The it that you're trying to figure out is the collective work of generations of judges, for sure, but other people too, trying to make our constitutional order as good as it can be. And that's what you're trying to figure out, and that's the same project the court is engaged in. So where does that leave you as far as, where does that leave, say, a president, as far as figuring out what the, whether the decisions of the Supreme Court are the law of the land? Well, yes, the question is, I haven't taken an oath to comply with the Constitution. What does that mean? Well, do I ignore Supreme Court decisions? Of course I don't ignore Supreme Court decisions. That's part of what the Constitution is what the Supreme Court has said. It's not all of what the Constitution is. No one ever said that. It's just part of it. So I'm going to approach this, let's say, as a rough approximation. I'm the president. I'll approach this in the way a Supreme Court justice would approach the same question. I see we have some precedent on this issue. Am I willing to go along with it, or do I think it is basically wrong and needs to be changed? But I'm not going to ignore it and pretend that because I've taken an oath I can reinvent the Constitution. But I also don't have to follow it as if they can give orders to me as if I were a lower federal court. There's no obligation to do that either. So I'll take seriously this precedent. I'll think about the things that a judge thinks about when a judge is confronted with precedent. Does it make sense? Does it really fit with the fabric of the law? Is it morally defensible? Defensible as a matter of fairness and good policy, or does it really make no sense as a matter of fairness and good policy? That's what I'll be thinking about. I won't claim to be free of all of that any more than a judge claims to be free of all of that. But I also don't think I have to follow it just because the Supreme Court said it. I get to think about it as if I myself were a justice. Now, as I said, that's a first approximation. There are going to be some ways in which that has to be qualified. But I think once you recognize that, yes, you've taken an oath to uphold the Constitution, but if you think that means you are entitled, much less obligated, just to pick up the document, read it naively, and think what you mean, no, that's not what it means, because that's not what the Constitution means. The Constitution is a lot more than that, and a good thing, too. It's a lot more than that for the judges. It's a lot more than that if you're in Congress. It's a lot more if that you're a state or local government official. It's a lot more than that if you're a president. Now, a couple of complications with that. One of the things that courts think about when they're figuring out what the Constitution requires is their own strengths and weaknesses as an institution. It is absolutely routine for a court to think, in some respects, we're probably not very good at doing that kind of thing, evaluating the economic and social consequences of complicated pieces of legislation. We're not so good at doing that kind of thing. protecting the rights of minority groups or otherwise not getting a fair shake, we're actually, we have a comparative advantage there. We're relatively good at that. Courts think that way. Other officials should think the same thing. Is this the kind of thing where I should be careful about overstepping my power? Because I actually don't. The courts probably have a better handle on this than I do. Maybe because, I have to appeal to an electorate and there's some risks that go along with that, or I have to run a government and there's some risks of being a little bit too quick to discount dissenting opinions or to think that people who criticized me are undermining my mission. I might be a little too quick to think of that. So if the Supreme Court has said something about that I'm inclined to disagree with, maybe I should back off and give them a little extra leeway. On the other hand, on some other issues where maybe the court stepped in, and I don't think they have any special claim to competence. In fact, I think I'm a little better at these things than they are. Well, then I'll be a little more aggressive. Just as the courts are sometimes more aggressive and sometimes less aggressive, depending on their assessment of their ability, I think executive branch officials and state and local government officials are entitled to do the same thing. And again, you're thinking, well, yeah, and what world is that in which people are being so conscientious? My world, okay? Let's just let it be my world for a while. This is really the point about assuming good faith and trying to establish what you would do if you were acting in good faith. One consequence of this, by the way, is that the Supreme Court's most famous statement of the position that Supreme Court decisions are the law of the land might be, which has been much criticized for reasons I've mentioned earlier, might actually have been right in the context. The statement came about in the context of the fight against Jim Crow segregation. The case was Cooper against Aaron, a famous case lots of you know about, I'm sure, that involved the desegregation of the Little Rock, Arkansas school district, where the governor of Arkansas demagogically opposed efforts to desegregate Little Rock schools. The case reached the Supreme Court. The Supreme Court wrote an opinion that was not just unanimous, but signed by all 9 justices, that said, Supreme Court decisions, including the decision in Brown, are the law of the land, and state and local government officials have an obligation to comply with them. A statement that, as I suggested, you could criticize by saying, well, where did that come from? In those circumstances, though, where what you were dealing with was a minority group that had been disenfranchised, disempowered economically and socially, was being protected by the court, it was actually right for the Supreme Court to say, no, on this kind of issue, you defer to us. You're the governor of one of these states. You have no business questioning our judgment on this kind of issue. On different kinds of issues, maybe the Cooper against Aaron statement is not right. But on that issue, they were right. If you're talking about a decision about committing foreign troops abroad to military action, then that goes in a different category, where the executive branch has the advantages, and to the extent the Supreme Courts have stepped in, the Supreme Court does not get the degree of deference it would get on a question about minority rights. And just further on that point, if you look at least the way conscientious executive branch officials have made decisions about those questions where the courts probably are not going to step in, they have done it. They haven't done it just by saying, well, I've read the Constitution, here's what I think. They do it by saying, well, what have we done in the past, and what's worked in the past, and what are our traditions, much the way a court would do it. They build up a body of precedent within the executive branch and look to see, well, what have my predecessors done if they're being conscientious? Again, showing that what we're dealing with here is a long-term, multi-generational project of figuring out what the Constitution requires and forbids, not simply a well-thumbed document. Okay, one last point about this, and I'll go back to my naive assumption about people acting in good faith. You could certainly object and say, well, fine. I mean, I understand you have to sort of work out how would people work in an ideal world in which people are just trying to be conscientious. But since we don't live in that world, I think we can all confidently agree with that. Don't we have to take into account in designing our system the risks that some people will not act in good faith? And if you establish the position that, yes, sometimes it's okay for presidents to say, I know the Supreme Court said that, I disagree, I'm going to act like Lincoln. If you establish that, and I knew Abraham Lincoln, and you're no Abraham Lincoln, buddy. I didn't actually. I mean, Bo's that old, but I'm not. If you establish that as kind of an acceptable way for presidents to act, aren't you opening the door for abuses of power by people who are inclined to abuse their power or tempted by abuses of power? And isn't it a concern that presidents in our system already exercise enough power, and the risk of creating a culture in which they will feel freed even from this one remaining restraint is too great to take, too great a risk to take? And I think that's a serious question. That to sort of assume, yes, it's good to have kind of a description of what ideal good faith action will be, but there are costs to propagating that because it will be seized upon by people who are not acting in good faith. I think that's a real risk. I'm not sure elevating judicial supremacy is the answer to that, and saying that the solution to that is to insist that presidents must comply with what the Supreme Court has done, because Supreme Courts can abuse their power too. And it's sometimes in our history they have, and of course that's what Lincoln recognized. So I think that is a genuine problem, it's a genuine concern, and it's possible that you just want to say, you know, we just don't want that as part of our political culture, that presidents can do this. I get that point. I just think it is, it's not clear what the answer is, but it's not clear that is the answer, to sort of weaken the ethos of presidential compliance with the Supreme Court. A real risk, but it doesn't, for me at least, get to the point of saying we should therefore reject the Lincoln view across the board. One more point, maybe more relevant to current times. If you look at the presidents who have taken this very strong position vis-a-vis the Supreme Court, Jefferson, Jackson, Lincoln, and Franklin Roosevelt, there's something in common that all of those presidents had. Here's what it is. Those statements by presidents came about at a time when the Supreme Court was dominated by people who had been appointed by a different political party in a different generation, and that party had since lost power. So the Federalist Party was clobbered in the election of 1800. The Jeffersonians beat them. Before they left office, they appointed a bunch of judges and justices. And that's what Jefferson was reacting to, that you entrenched yourself in the judicial branch, having been rejected by the people. So you tried to lock yourself into the judicial branch so you could continue to influence policy for a generation, even though the people had rejected you. It was a similar situation for Jackson. For Lincoln, it was the slave power that had gotten hold of the judiciary and tried to dominate the issue from the judiciary. For Franklin Roosevelt, it was also a conscious effort in the aftermath of the Civil War and Reconstruction and the Progressive era, a conscious effort to try to entrench people opposed to social welfare and regulatory legislation in the courts when they were losing the battle in legislatures. So I think it is not out of the question that we could see this issue arise again, to the extent we are seeing a similar dynamic playing itself out in American politics today, an effort to entrench a certain group in the courts so that they can continue to exert influence over public policy even after they are repudiated by the electorate. I think that is a possible scenario for the next generation. And if it is a situation in which this issue could arise. And if it does arise, I think we want to be able to be in a position to say to people who are responsive to the electorate, to a president or members of Congress or people in state and local governments who are responsive to electorate, who are being frustrated by the courts, we want to be in a position to say to them, well, here's what you can do in good faith. Here's what you can do and still exercise your constitutional responsibilities. Yes, maybe you have some power now, and maybe you're frustrated with the courts, but you, maybe unlike some of your predecessors, you have to act responsibly. And then we need to be able to tell them what responsible action is. And in this case, I think responsible action involves acknowledging the complexity of our constitutional traditions, recognizing that the Constitution is the work of many people, many generations, judges, justices for sure, but others as well, in an effort to try to make our society a little bit better as we go along. So thank you very much. So we have time for questions, Elizabeth? Great. Ma'am, in the back.
Thank you so much for your wonderful lecture. I have a question about where you ended up, which is what's the constraint on
Well, as far as the constraints in practice, they're the familiar ones, and maybe they're not adequate of having to run for office, having to be concerned about eroding your political power if you become unpopular, even though you don't have to stand for re-election. It's still important to maintain your popularity if you want to continue to govern effectively. There's that electoral constraint. Maybe in some circumstances a constraint through elite opinion, to the extent that presidents or office holders care about elite opinion. That I think would be particularly significant here, because the idea you're defying the law is likely to maybe carry more weight there in certain elite circles. Legal circles, lawyers are important in governments, and lawyers can exercise this. So as far as the real world constraints, that's, I think, the best I can do, and there's nothing original in those thoughts. Really, the way I come at this, this is just the limitations of the question I've asked in this connection, not to say this is the right way to think about things, is, as I said, let's suppose someone wants to do the right thing. What do you tell them are the limits? And if they don't want to do the right thing, then you have to think about these other mechanisms of control. But first you have to figure that part out. And as to the mechanisms, I think they're just, as I said, those familiar ones. I mean, is that responsive?
Yeah, thank you. And I guess a related question is, what do you think about court packing, which of course was another phenomenon in the FDR era and seems to be a topic of discussion these days?
Yeah, I mean, that sort of stuff, court packing is a piece of this. If you really took the view that the law is what the courts say it is, in a sense, what's the justification for court packing? I mean, they've told you what the Constitution is. How can you possibly want to change the composition of the court, to move it in what is by definition a non-constitutional direction? So even to think about the possibility is to acknowledge that, no, it's more complicated than that. It's not just what the Supreme Court says. There are a lot of elements of our system where probably the best state of affairs is one in which no one is quite sure what is allowed and what is not, so everybody is careful. And court packing might be an example of that, we're not really sure whether it's an okay thing to do, ever. And maybe as a result, the courts watch their step because they don't want to go too far, and the executive branch and Congress also watch their step because they don't want to do something destructive of our traditions. So the possibility is there, but it's not exercised, and that's a good thing. There's a little bit of, and having said that, I think that's possible. There's a little bit of magical thinking there. Why are we sure that's the right equilibrium? Where there's a threat never exercised of court packing, and the court stays in line, and the executive branch stays in line. That is sort of, as I say, that's kind of a leap of faith to say that. But I guess my inclination is to think that's at least now where we should be in thinking about those issues, that we shouldn't extinguish the threat altogether, but it would be a huge step to implement it. But that's very far from clear to me. That's right, sir.
A lot of the examples you cited about presidents sometimes directing a legislative agenda, but I think one could reasonably make the argument that the branch of federal government that has been least tethered to direct text of the Constitution has been the Congress. Right? Do you think Congress has a special claim to kind of creating? Do you think that Congress has a higher or lower duty to the Supreme Court's interpretation of the law than the President?
Yeah. In the abstract, there's no reason to distinguish between them. They're both coordinate branches. And for that reason, there's no reason to distinguish the courts. They are all trying to figure out the right answer to the question, what does the Constitution require or forbid? And they're all doing it relying on the same materials, a lot of which is not just the text and the original understandings, but precedent understandings as well. Now, in practice, there is actually, I think, a significant difference between Congress and the other branches, which is it's much more difficult for Congress to act as a unitary actor. So the executive branch really can put together a body of executive branch precedent and say, if you want to look at how presidents have justified various actions, committing the nation, committing troops abroad, abrogating treaties, engaging in executive agreements short of treaties. We can tell you, here is what presidents have thought, here are the memos that the Justice Department's Office of Legal Counsel have written to justify it. All of them kind of worked out in a somewhat judicial fashion. It's much tougher for Congress to do that because it's a much bigger, more diffuse, more heterogeneous body. So I think in practice it is probably wiser for Congress to feel itself more confined because it can't confine itself otherwise. It doesn't have this internal discipline that the courts certainly have because there's U.S. reports and when they're overruling a previous decision, and even the executive branch has to a degree because it feels an obligation to justify its actions. So I would say Congress ought to feel less freedom to depart from what is the received understanding of the Constitution for that practical reason. Sir.
I wonder, first of all, thank you very much for coming.
No, totally my pleasure.
I wonder if would it be fair to say the Supreme Court precedent is the law of the land, and it would be lawless to ignore it or to defy it, but sometimes we tolerate lawlessness, and sometimes we tolerate lawlessness across sometimes we even want lawlessness. And so if President Lincoln did something lawless, for whatever reason we've accepted that. We want to maintain the idea that this is the convention or the fiction or the truth that precedent is the law of the land because that's necessary for us to function, but sometimes we will just tolerate people who don't do that.
Mm-hmm.
And sometimes we won't.
So on the question whether, basic answer is yes and possibly to your two questions. We have to acknowledge the possibility of what amounts to civil disobedience by government officials, which is to say, yes, I know this breaks the law, I'm morally required to do it. That has to be a possibility. We can all think of hypothetical instances in which that would clearly be the right thing to do. And there is no plausible legal argument to be made that this is a permissible action. Nonetheless, it has to be taken. We can all imagine those instances. No legal system is perfect. Ours, historically, certainly very far from. So that has to be the case. Then the second part of your question, if I understand it correctly, is, well, why don't we just stop there and say, yes, let's treat Supreme Court decisions as the law of the land, acknowledging the possibility that sometimes it is the morally correct thing to do to act lawlessly. And I can see that, as I said, as an argument for, if you approached it not the way I approached it by saying, let's try to figure out what a good faith actor would do, but if you approached it by saying something like this, let's look for where the abuses of power are most likely to crop up. And then let's build some fences around those people to minimize the chance they will engage in abuses of power. And that should be our legal culture. Our legal culture should establish those fences. And of course, recognizing the possibility that sometimes the right thing to do might be to break through the fence, but still that should be the fence. If you came at it that way, I could see the argument, as I said, for saying where the abuse is most likely to come. With the current way our government has evolved, they're most likely to come from the president. The president is by far the most powerful actor in our system. So let's not say to the president, you have any leeway to defy what the other branches do. I can see that argument. It is that kind of argument, is an argument based not on what is the proper understanding given good faith action. It is an argument based on let's assess where bad faith action is most likely to occur. And my hesitancy is, of course, that's just filled with lots of empirical and normative uncertainties about the likelihood of abuses of power, the likely source, the costs that you'll incur by not allowing presidents to do something, if you build this fence, and then how you want to weigh these dangers. Whether it is just what value we assign to the importance of ensuring that actors act with sufficient flexibility and not feel too fenced in. But I wouldn't want to rule out the possibility of what you say. It's a different question, but that might be the right answer to that different question. Last question? One more. Sir. I'm sorry. Okay.
I can ask that.
Fine.
Don't fight over me, guys. I'm happy to hang around afterwards, actually, in seriousness.
For many, many years. And it seems to me as a voter, they're getting more politically voted in, maybe or maybe not. But it also seems that since it's a lifetime appointment, they have to sit with that hand on. Do you think we're going to see the migration we've seen historically, that they free themselves up of their political promises and actually look to the law? Or do you think they're frozen in a position?
So I have two answers to that. There are instances in history, fairly famous ones, where justices seem to have moved from the positions they took to other positions. And Theodore Roosevelt famously saying about Justice Holmes when we appointed, I could have carved more backbone out of a banana because Holmes did something he didn't like. And so there are famous instances of that. What you don't see, where that happens, is where a president appoints a justice with one issue in mind, and then that issue kind of disappears from the scene and other issues crop up. And so they were perfectly predictable on the issue they were put on the court to deal with, but the president wasn't paying attention to these other issues, and that's why they turn out to be unpredictable on those issues. So I think that is just a question of what the future issues will be. If they're the same issues that have dominated the appointments process to date, I don't think you'll see unpredictability. But if the new issues are things about, say, the sort of use of government power in the war on terror and threats to civil liberties, which is not something that was a particular issue in these appointments, I think you could see some unpredictability. I do think that there's been a troubling trend just in the last decade or so in appointments, that there used to be fairly powerful centripetal forces to encourage presidents to move toward the middle on appointments. There was the filibuster, and there was also kind of a sense of elite opinion that you wanted people who were, yes, they were Republicans, yes, they were Democrats, but they kind of fell within a certain, there were sort of people everybody could live with quite comfortably. And I think we've lost that. And I think the process has become polarized in a way that each party now has an incentive to say, let's get the person who agrees with us most completely that we can get through with 51 votes. And I think that's a very troubling trend. I think it's a very troubling trend for the court, and I think it's something that we haven't seen for quite a while. I mean, we've seen it at other points in our history, but we haven't seen it for quite a while, and I do think that's troubling. Thank you very much.